Alright guys, welcome back to Regnum Legal. Today we're going to discuss the Healthcare Directive. And in my opinion, the Healthcare Directive is one of the most important estate planning documents you can have in your arsenal of estate planning documents. And the reason is this: your living trust and your will are all things that are going to take effect after you die or become incapacitated. Your healthcare directive is really the only document that's going to directly impact you while you're still alive. And not only that, but it's going to impact you in one of the most private and sensitive ways imaginable, because it's going to tell your family and your doctors the types of medical decisions you want at the end of your life. Whether you want life-sustaining treatment, artificial nutrition and hydration, whether you want to be resuscitated, whether you want to be in a coma, for how long, and at what point is your family or your doctors allowed to just give up. So your healthcare directive is one of the most important and private documents you can really have. And frankly, as an estate planner, it's one of the hardest documents to craft, because often it really has nothing to do with my opinion as a lawyer, and it has everything to do with my client's intention and their desires, which can at times be very hard to articulate. So in this video, we're going to discuss two examples of what I would call healthcare decisions gone bad, and how either the presence of a healthcare directive or a better drafted healthcare directive could have prevented disaster. So the first scenario is something you're probably already familiar with, and it's the case of Terri Schiavo. If you'll recall, the case of Terri Schiavo involved a really young woman who at the age of 26 had a heart attack, and she was able to be resuscitated but was left with significant brain damage. Subsequently, the doctors listed her condition as a persistent vegetative state. But persistent vegetative state doesn't really accurately capture what was going on in Terri's life. For example, Terri was able to recognize people when they came in the room. She recognized her mother's voice. She recognized her priest's voice. She recognized when people were praying. As an example, one of her priests told me that when he would pray, Terri would close her eyes and bow her head, and when he was done praying, upon saying amen, she would lift her head and open her eyes again, indicating that there was at least some understanding on the part of Terri about what was going on. But Terri couldn't communicate. She couldn't talk, and the ways she could communicate and express emotion and express recognition was extremely limited. And in the early parts of 2000, you may remember the court battle that went on between Terri's parents and her husband. On the one hand, Terri's husband wanted artificial hydration and nutrition to be withdrawn. The backstory here is that her husband wanted to be remarried to his girlfriend and couldn't validly be married in the Catholic Church until Terri died. So he asked that the doctors withdraw life-sustaining measures, including artificial hydration and nutrition. Her parents, on the other hand, claimed that Terri was a devout Catholic and would not want the ordinary means of preserving life to be withheld from her. And it resulted in this very long and drawn-out court battle that made headlines across the country. At the end of the day, the court sided with the husband. And as you might recall, Terri's artificial hydration and nutrition were withdrawn from her, and she died several weeks later. Now, I bring this story up not to cast judgments one way or the other about the decision that was ultimately made, but to underscore the value of a healthcare directive. You see, the entire legal battle happened because Terri Schiavo did not have a healthcare directive. Both sides were arguing what Terri would have wanted, but there was no document in place signed by Terri that expressly and clearly stated what her wishes were. And so there was an expensive, lengthy, and very public battle between Terri's husband and her parents. all of that could have been avoided with the healthcare directive. And now let me tell you the second story. And this is a story that you don't know about, but I know very personally, because this was a story of a client of mine. 5 or 6 years ago, I got a phone call from a client. His dad was in the hospital after an accident. Prior to this accident, his dad had signed a healthcare directive and named the son, my client, as his healthcare agent. The healthcare directive stated that the father did not want to be on a ventilator for more than 3 days. At the time my client called me, his father had been on a ventilator for 3 days, and the doctors had informed him that pursuant to the healthcare directive, they were going to take the father off the ventilator. Additionally, the hospital was concerned because the healthcare directive expressed a desire not to receive life-sustaining treatment if the father was in a coma. The client called me concerned for 2 very important reasons. First, the client was adamant that the father did not want life-sustaining measures to be withdrawn at this particular point in time during his medical treatment. And secondly, the client was concerned because although the father had been in a coma for 3 days and had been using a ventilator to breathe for 3 days, the coma was actually medically induced. And so the client was concerned that the hospital was creating the condition that triggered the father's healthcare directive to withdraw life-sustaining measures. I got involved and sent numerous letters to the hospital. We threatened litigation. We threatened lawsuits. Ultimately, the hospital's ethics board reviewed the case and concluded that life-sustaining treatment had to be withdrawn. We again appealed to the ethics board. This time we argued that the coma that he was in, since it was medically induced, was actually an injury or a circumstance caused by the hospital itself. Therefore, we argued the medicine that they were using to keep the father in a coma should be withdrawn. And in the event the father woke up, we could ask the father whether or not he wanted the ventilator, because the condition that the father was in was not irreversible. It was curable. The issue was, how long could they keep him on the ventilator, and how long did he want to be in a coma? So the hospital ultimately, reluctantly, agreed to stop giving the father the medicine which would keep him in a medically induced coma. A few days later, the father woke up. And one of the first questions the son asked him, my client, and the medical staff asked him was, "Do you still want the ventilator?" And the father shook his head yes. Within 2 weeks, the father's lungs had healed, and he walked out of the hospital alive. But had we not intervened, life-sustaining treatment would have been withdrawn, and instead of walking out of the hospital with his father 2 weeks later, he would be standing at his father's grave. Now, I bring this up not to scare you, but to underscore the importance of a properly written healthcare directive. Because in this case, the dad did have a healthcare directive. And in this case, the dad did express his desire to not be in a coma and not have a ventilator. The only problem was that it was not clearly written. When you're writing your healthcare directive, you need to write it as if you know a doctor is going to read it. And you need to write it such that when the doctor reads it, the doctor can clearly understand, number one, what you believe, number two, what exactly you want, and number three, what are the triggering circumstances that will require an act to be taken or withdrawn. In my client's case, his father's fault was not the healthcare directive itself. The fault was the father's misunderstanding about what he was writing in. The father really wanted not to be in a persistent vegetative state. That's what the father really meant. But he didn't know how to communicate that. So he put, "I don't want a ventilator and I don't want to be in a coma." Because in the father's mind, that meant persistent vegetative state. And so the way the doctors interpret it was completely different than the intent of the father drafting it. So when you're going over your healthcare directives, it's really important to be very, very clear on what you want and what you don't want. Now on regnumlegal.com, we have a healthcare directive template that you can follow. And we've got 5 different versions. We've got a general healthcare directive for anyone. And we've got a Catholic version, a Jehovah's Witness version, a Christian Scientist version, and a person of the Jewish faith version. And each of those religious type directives are geared towards articulating a particular religious belief so that the hospital, the doctors, and the agents can understand how to implement medical treatment given a particular type of religious beliefs. The General Healthcare Directive has numerous standard options that you could choose from with regard to artificial nutrition and hydration, the choice to prolong or not prolong life, and the circumstances that would trigger those kinds of treatment or the withdrawal of those kinds of treatment. Now, you can access those forms at regnumlegal.com/resources. I'll put a link in the description below. You'll have to fill out a waiver and a disclosure and an agreement of our terms and sign up with your email address and your name. We don't give out your email address. We don't sell your email address to third parties. We don't spam you. And in addition, on our website, regnumlegal.com, we've got a tutorial where I go over the exact form that you can download from regnumlegal.com and exactly how to fill it out and where you should put certain critical information. Okay, all of that can be accessed for free. For free. And the reason I'm doing this is, number one, I want to help you. Right now, we're dealing with a pandemic crisis and a lot of people are worried. I don't want to take advantage of that, and I want to make it as easy as possible for people like you to get the help that they need. Number two, since we're in a pandemic crisis, it's imperative that every one of us have our healthcare directives in order. So if there's only one document that you focus on during this time, it should be your healthcare directive. And I'm hoping and trying my best to make it as easy as possible for you to articulate your wishes in ways that are clear and effective. Guys, if you liked this video, please subscribe to my channel below. And as always, thank you so much for watching, and I'll see you next time.